Hi, I'm Emily Martin, Vice President and General Counsel at the National Women's Law Center. As you've heard, the Supreme Court's agreed to hear two cases challenging the constitutionality of the health care law that passed in 2010. Women have a lot at stake in these cases. The health care law is the law that provided that being a woman would no longer be considered a pre-existing condition, that ensured that women would be able to obtain health insurance coverage even if they were survivors of domestic violence, even if they've had past cesarean sections. It expanded the availability of health insurance and made it more affordable, and will do even more by 2014 when all of its provisions come into effect. The two pieces that are being challenged specifically in the Supreme Court really go to the core of these protections for women. The first one is the individual responsibility provision, which requires people to obtain health insurance and give subsidies to low and moderate income people to make sure that they can afford to do so. The challengers of that provision argue that Congress doesn't have the authority to require someone to get health insurance if they don't want to. Fortunately, we think the law is clear otherwise, that a long history of Supreme Court precedents, including, importantly, the civil rights laws, makes clear that Congress, under the Commerce Clause of the Constitution, can regulate these sort of economic decisions and economic transactions, like the decision whether or not to purchase health insurance. Just like Congress can pass laws saying, for instance, that a hotel owner can't decide not to provide a room to someone because of his race, that an employer can't decide not to consider someone for a particular job because she's a woman. So Congress can pass a law saying that you can't decide just not to get health insurance and to place the risk that you'll have catastrophic health care costs on the broader society. We also think that the constitutionality of the expansion of Medicaid under the health law is clear. By 2014, over 8 million women will have Medicaid coverage for the first time as a result of the new law, among others. The law has always been clear that federal programs can give money to states with certain strings attached. Medicaid is like that. Congress said to the states, here's some money to run a Medicaid program. If you accept it, here are the rules for how you run it. Some states have argued that because it's politically hard to say, no, we don't want to have a Medicaid program, that putting those rules on the states about how you run the program, expanding eligibility, is a violation of the states' rights to make their own decisions about how to spend money. The Supreme Court has never accepted this sort of argument, and if it were to accept that argument, it would have huge ramifications for how federal programs like Medicaid are run, as well as for anti-discrimination rules like Title IX, which say, for instance, to a state, if you accept federal money in your education programs, you have to agree not to discriminate on the basis of sex. We think the precedent is clear that the Affordable Care Act, the health care law, is constitutional, but women should watch these cases closely because the effect of the Supreme Court's decision will not only impact the Affordable Care Act and the provisions that extend health care and important health care protections to millions of women, it may also have effects on other laws important to women. For more information, go to our website, www.nwlc.org/healthcarelawlitigation. Thanks.